development specialist on calls like this. We really get into the detailed knowledge of things. What is URA? So URA is the Uniform Relocation Act. Actually, it's the Uniform Relocation Assistance and Real Property Acquisition Policies Act of 1970. We just call it URA, but basically it's designed to provide protection for people that are in properties that have been acquired, real property has been acquired, and who may have to move as a result of the project receiving the federal assistance. It affects owners, tenants, residential and or commercial. And the URA is applicable to federally assisted projects. So like CDBG, ESG, home, housing trust fund, NSP dollars. The items that are affected by URA are number 1, acquisition, 2, demolition, 3, rehabilitation, and also new construction. Please keep in mind that new construction alone is not a trigger.
Right, so a lot of times our funds go towards construction, but the URA still applies. If there's acquisition and demolition or rehab in the project, URA still applies even if the funding is going to construction. And I meant to update this slide. Federal project-based vouchers also trigger URA.
Okay, so the applicability of acquisition, basically ask yourself a question: was it property, was it acquired? Was real property acquired for the project? And will that real property, if it's acquired, is it in connection with this particular project or program? So if the answer to either one of those questions is yes, then URA acquisition requirements will apply. The definition of acquisition. Basically, you're looking at a fee simple conveyance, fee simple rights of real estate from one legal entity to another. Donations are a type of acquisition. It basically, the seller is not getting compensation, but you are conveying the fee simple rights. Permanent easements are also subject to acquisition requirements. Long-term leases are also considered acquisitions for URA. The acquisitions may also occur between 2 affiliated or related party entities. And also keep in mind that all acquisitions that occur in a federally assisted project, such as the ones we just mentioned, home, CDBG, etc., they are subject to URA requirements. Voluntary acquisition. I sometimes refer to this one as the Tony Soprano transaction, meaning that it is taking place as a voluntary, not an involuntary transaction. So, but technically the definition means that it's a voluntary acquisition of the property. The documentation has to include that the property will not be acquired in the event that the negotiations have failed. The acquisition also includes an estimated market value for that property. And if compliance is not documented, then HUD will assume that this transaction was an involuntary, not a voluntary acquisition. For our applications, what we have what's called attachment E, and that is basically a notice that this transaction did take place on a voluntary basis. This is an example of attachment E, and fairly simple, but the key thing is we're making sure that we're definitely documenting that it was a voluntary, not an involuntary transaction. Okay, the applicability of relocation. This one is sometimes difficult to ascertain, but basically you want to find out, was the site occupied by any residents or businesses in the 3 months or the 90 days prior to the purchase office, or 90 days prior to the application for federal funds. If the site was not vacant within 90 days, then relocation requirements under URA may apply.
So we're gonna go get right into the nitty gritty here with defining the initiations of negotiations, which I'll just call ION because that's easier. A little bit of backstory on the URA regulations. They live in the Department of Transportation regulations, and then HUD refers to them in their program-specific regulations. So there's a definition for you for ION in the URA regulations, and then it says unless a program-specific definition exists. And so for all of the funds that you would get from the Division of Housing, CDBG, ESG, Home, HDF, there does exist a program-specific definition. And for all of those, the wording is slightly different, but it is the date that the contract is signed with the state. So the contract for federal funds signed with the state between you, the developer, and the state is the date of ION for in most cases. And the ION is an important date to know for, it's an important milestone for determining eligibility for relocation assistance. One important caveat is that the ION is a project ION. What I mean by that is if there's more than one federal funding source in the project, there's still only one ION. So the earliest ION date is the ION for the project. So if you get federal funds through your local government in February, and then you don't apply to the state for federal funds until December, then the ION date is still the original ION date that was set with the original federal funding source. I should also note while I'm on this topic that HUD has informed us that when there is more than one federal source of funds in a project, both entities are responsible for ensuring compliance back to the beginning of the project, right? So if the state's putting in funds later in the project and we're asking you questions about what happened way back when, that's why we're asking those questions. It's not just because we're like bored that day. So there is another caveat that I have to mention, which is the program-specific definition for most of these funding sources, definitely CBG, Home, HDF. For some reason, in the definition that says it's the state of the contract when the acquisition, rehabilitation, or demolition is privately undertaken. So if you are a public housing authority, the program-specific definition doesn't apply to you, so you go back to the URA definition. So I'll tell you what that is, just so those people know. So the URA definition is either the initial written offer, the voluntary acquisition notice to the seller, or the notice of displacement for the person who's being displaced, or the actual move of that person from the property. Whichever of those dates is earliest, that's your ION if you're not a private developer. So a little bit complex here, but it's important that we're all on the same page on what the definition of ION is, because it's an important date when we're talking about these regulations. So the notices, this is what a lot of people think about when they think about relocation, the notices that you have to send out. So the first one is the general information notice, the GIN, and it's just pretty much what it says, a general information to the tenants, notifying them of the potential project. It should be sent either at the time of the voluntary acquisition notice to the seller or the application for federal funds, whichever comes first. A lot of times people are applying to us and they don't know whether they're getting federal funds or state funds, so I would assume that you're getting federal funds and send out those notices in all cases. And it should, be specific to that situation. It should advise them not to move, all that jazz. There's a link later, but there's guide form notices that HUD has published for all of these notices. So if you have any questions about what needs to be in the notices, those guide forms are a really good place to look and copy. Move-in notice is if there's a long period of time between when you're applying for federal funds and between when the relocation is actually going to start, and you don't want the property to be vacant in that period of time, you have the option to issue this move-in notice that is issued before the tenant signs a lease that says that they may be relocated and they won't be eligible for relocation assistance in that case. So you have the option to protect yourself and have people move in as long as they sign that before they sign the lease, and it's very clear to them that they won't be eligible for relocation assistance. That is an option for you. The tenants who will be permanently displaced should be getting a notice of eligibility. And this notice will tell them that they're being displaced, what the comparable offers are, where the replacement dwellings are. It should have a dollar amount for the amount of assistance that they may be provided, outline how they go about receiving these monies, and it needs to be sent, this ION date comes up again, it needs to be sent either before or, quote, promptly after ION. What promptly after means. In this notice, this is often a good place if there's a requirement to offer them 3 comparable replacement dwellings, which we'll go into in more detail, but this is the place where that would go, and it would have that dollar amount of assistance. The 90-day notice, obviously you can't just kick people out without giving them notice. So the 90-day notice gives the tenants 90 days of notice before they're required to move. It should have an actual date in it. Importantly, they must have already received the notice of eligibility. So if you're need to displace people before the ION date, then you need to issue the notice of eligibility early enough before that ION, even though it's not required until ION, it needs to be before the 90-day notice. So just depending on the timing of various things in your project, it's a little bit different for everybody, but that needs to be 90 days before. Another option is you can send them a 90-day notice that says, within 90 days, we'll send you a 30-day notice, and then that 30-day notice can contain a date. If that's something you really need to do, that is an option. For tenants who won't be displaced, logically, they get a notice of non-displacement. Notified, they won't have to relocate, you do still have to pay your rent, whatever. This includes people who are ineligible for relocation assistance. So we'll talk about that, but unlawful occupants or people not lawfully present in the United States would get the notice of non-displacement. It must advise them of their right to appeal, and you can put a date on that. I think it's a minimum of 60 days for them to appeal, and it should tell them how they should appeal if they want to. And for anybody who's going to be temporarily relocated, they also get a notice of non-displacement. And if they're being temporarily relocated, it needs to go into detail about what that temporary relocation looks like. So date and time of the relocation, the address that they'll be moved to, the terms and conditions in which they'll be moved. So make sure. So yeah, this notice of non-displacement can either be pretty simple or like really in depth about the temporary relocation. And here's that link to those notice templates.
Hey, Teresa, can I add something about ION?
Please.
So my experience in working with Teresa and different applicants on the ION date is it seems fairly straightforward in the regulations, but actually there is often quite a bit of debate and quite a bit of confusion.
Yeah, sometimes it takes, some digging to figure out when that ION date actually was for a specific project. The procedure for sending out these notices, obviously they're being sent to a tenant, so it should include the tenant's name and address, should be specific to the tenant situation, whatever that is. You need to verify and document tenant receipt of notices, so that's either a signature from the tenant saying that they received it, or it being sent via certified mail with its return receipt. If it's not documented that it was sent, then we can't, or received, then we can't show that it was received, and so it's assumed that it wasn't received, right? And just, looks like Wayne just left. All notices should just be sent as soon as possible. Any tenant who is not issued their notices in a timely manner and should have been, they are considered by HUD to be permanently displaced, and you'll be treated as such, and you'll be required to pay any relocation benefits that are applicable. So a little bit more about the timeline of these notices. Just to reiterate, the GIN notice needs to be sent prior to acquisition or federal funds, whichever comes earlier. The regs also state that it should be sent as soon as feasible. I had somebody tell me one time that they didn't want to send the notices because they didn't want to freak out their tenants, but my response was like, well, how much worse would it be if like somebody heard from the newspaper that their place is going to be renovated, and then they assume that they can't live there when will not be able to live there, won't be able to afford it when it's renovated. And so just get those notices out as soon as possible. And it's not required, but we often recommend hand delivering them, because then you can talk them through, like, hey, this is the notice that we're required to give you, and this is what it says. Like, read through all that legal mumbo jumbo. The notice of eligibility and the notice of non-displacement, both the trigger for that is that ION date again, so before or promptly after, and then the 90-day notice, obviously 90 days before they'll be required to move, whether or not that's prior to ION, right? Here's this sort of the same information in a slightly different format. Again, GIN, notice of non-displacement, notice of eligibility, ION, all that jazz. Again, all notices should be sent as soon as possible. So we're about halfway through the slides here. So you thought getting through the notices, you thought we were like near the end. No, there's a lot more to cover. So buckle up. This maybe should have been earlier in the project, but the first thing you need to think about when you're planning your project is how can you minimize displacement? Now, I know like all of you have, 5 different sites that you have a possibility of developing, and you own them all, and the point is just that if you're considering multiple sites, or if you're like thinking about where you might place your newest project, minimizing displacement should just be one of those considerations. Just so we're not kicking out people just for the fun of it. Pretty self-explanatory, but you can't just issue notices to vacate or refuse to renew leases in order to evade responsibility to provide relocation assistance, right? If somebody wants to move out, they're certainly allowed to, but you can't just start evicting people left and right. And also, if somebody does move out, or you do need to evict somebody while you're in the midst of the relocation process, just like really make sure to document that well, to show that it wasn't the purpose of the eviction or the vacating was not for the purposes of evading responsibility under URA. Advisory services, everybody in the project is entitled to advisory services, which includes a personal interview with them to tell them, to discuss with them what their needs are, what the procedure and timeline will be, just reiterating a lot of that information that's in the notices, any reasonable accommodations they need in the replacement dwelling, whatever it is that they need during the relocation process. And finally, minority persons should be given a reasonable opportunity to move to an area of non-minority concentration. So when you're offering these replacement dwellings, if you're relocating a minority person, the regs state that you should be offering them options that are in areas of non-minority concentration. And of course, the person being relocated can choose to accept that offer or not. It's up to them, but the offer should be there on the table. You must offer at all of your tenants at least 3 comparable replacement dwellings. Unless you literally live in an area where there's only one vacant unit in your entire town, it's got to be at least 3. Those replacement dwellings need to be decent, safe, and sanitary. And in order to ensure that, you should be inspecting the units prior to offering them to the tenants. And the tenant, again, you've given them these 3 options. They can say, yeah, I like this one, or they can say, no, I don't like any of them. I'm going to choose my own place. As long as it's decent, safe, and sanitary, they're welcome to do that. Again, no matter where they move to, it has to be decent, safe, and sanitary. So I mentioned this word. I hope you can't hear the lawnmower going on outside my building. I mentioned the word comparable, which just means that, like, if you're displacing somebody from a 3-bedroom, 2-bath apartment, then you should be moving them to a 3-bedroom, 2-bath apartment. With the one caveat that if you're in a subsidized unit, that size requirement is based on the HUD unit size requirement, not the size of the previously occupied dwelling. So if somebody's underhoused, overhoused, whatever subsidized unit they move into, they'll use the HUD unit size for those programs, and not the size of the unit they were previously occupying. So we've got a chart here, which I think Wayne is going to explain.
Yeah, this one basically kind of shows what qualifies as a comparable. So look at the left side, you've got public housing. So public housing can be replaced with public housing, or private with project-based subsidy, or private with tenant-based subsidy, or private market. If you go down to the next line, private with project-based subsidy, that cannot be replaced with public housing, but it can be replaced by private with subsidy, private with tenant-based subsidy, or private market, and then so on all the way down. So when you get down to the very bottom, private market can only be replaced or as a comparable for private market. This chart is a little hard to read, so Teresa came up with something that's a little easier to read, and this one actually makes more sense. So here you can tell the umbrella, public housing, and then comparables of all the different types of housing, and you can see the smallest category, the smallest bubble there, private market, that can only be as a comparable as other private markets. So this chart is actually easier to understand as far as what qualifies as a comparable.
Just depends on whether you have a Wayne brain or a Teresa brain.
Exactly. But do you like LA traffic, or are you like normal? So,
right.
I like the LA traffic from the previous slide.
Right. Yeah. So just the gist of this is, if you're relocating somebody who's in a private market unit, you can't relocate them to somewhere that's subsidized. But if they're but vice versa, you vice versa, you can. Finally, we have got this definition of housing of last resort, which is a funny title for this, because it's not something that's uncommon. So there's 2 things. We already mentioned the first one is that you've offered your tenants 3 comparable replacement dwellings, and they decide that they want to choose one of their own choosing, and that's totally fine. The second one is that in the regs, there's a monetary limit for the amount you can spend on replacement housing payments. But it's an artificial limit, because you are also required to exceed that monetary limit if necessary in order to provide somebody with a decent, safe, and sanitary unit, right? So I don't even know what the number is, because it's like an artificial limit that doesn't really mean much. So if you can't find a decent, safe, and sanitary unit that's within that price range, you can build, renovate, whatever you need to do in order to create those units. If there's a great house that you want to relocate somebody to, but the roof is leaking, just fix the roof. And then if that fixes the problem and it's now decent, safe, and sanitary, that's totally fine. That's totally allowable. And even required if that's what you need to do in order to provide somebody a unit that's decent, safe, and sanitary. There's a few people who are not eligible for relocation costs. Evictions for cause, right? So if you need to evict somebody for a legitimate reason, that's totally allowable during the relocation process. It's just really important that you document that as much as possible so that it doesn't look like you're trying to evade responsibility. All communication with that tenant, court docs if you have them, everything you can get in writing, put that in the file and keep it handy. Voluntary move-outs also, like if you're in the middle of relocation process, somebody doesn't want to like bother with it and just wants to move to wherever they want to move to, that's also totally fine. As long as they've received all the notices they should have up to that point, and they must sign something that makes it clear that they've been notified, they understand that they would be eligible for relocation assistance payments and are waiving their right to those payments. You can't like solicit voluntary move-outs, right? That's not cool. But if the tenant wants to move out and forego the assistance payments, they are welcome to if they would like. Non-lawful occupant, so somebody who's living there without a lease or just like shouldn't actually be there. We had a project once where we relocated everybody, the units were vacant, there was like these vacant buildings and some people just started sleeping there because they were vacant for several months, and that's fine. We then had to kick them out in order to demo the units, but we weren't required to relocate them under URA because they were never there lawfully in the first place. Persons not lawfully in the United States also are ineligible for relocation assistance. And the owner occupant who voluntarily sells, right? So if you are buying the property from the owner who's also the occupant, there's no tenants involved, then it's a voluntary sale. They're getting that purchase price, and that's sort of like considered their relocation expenses, right? There's not a need for additional relocation. They're already getting the purchase price of the property that they're selling voluntarily. Emergency shelters generally are not considered displaced if the tenant does not have the guarantee of being able to return to that same location the next night, then they're generally not considered displaced. It's a little bit gray on the subject of like transitional housing. I would err on the side of assuming that they're considered displaced and treat them as such, just to be on the safe side. Yeah. So you may be wanting to know what's the like actual dollar amount that this is going to cost me, right? So two different types of costs that you have to reimburse under the relocation regulations. So that's moving costs and that's replacement housing payments. So moving costs we'll go over first. Obviously, any tenant that you are moving, displacing, you should pay for their moving costs. This includes costs associated with packing, transferring utilities, particularly with like businesses. If there's costs associated with uninstalling and reinstalling equipment, you'll need to pay that, whatever those costs are. And there's two options for determining that payment amount. So you can either use actual reasonable expenses. So the tenant like collects all those receipts, you look through them, they're all reasonable, then you pay the actual amount that they had to pay. You reimburse them the actual costs that they incurred. Or you can use the fixed payment schedule, and HUD publishes a fixed payment schedule. So that's, I think it only applies to residential, but that's fairly easy. Like if you have 2 bedrooms, you get X number of dollars. And then you can just do that pretty easily. And now, in most cases, the displaced person gets to choose which of those options they want. you can't put a maximum cap on your moving costs as long as they're reasonable, right? So if you've got somebody who maybe they have a lot of medical equipment that's expensive to move, maybe they have a live-in aid that also needs to be moved, maybe for whatever reason, whatever legitimate reason, their moving costs are quite expensive. As long as they are reasonable, then you have to pay the full actual amount. If they're paying their uncle like 5 times the going rate, then that's not reasonable and you wouldn't be required to pay that. But there's no, you can't establish a maximum cap up front. This is one more area where public housing agencies are a little bit funny. So for public housing agencies, you are allowed to choose the method of payment. So rather than the tenant choosing between actual reasonable expenses and fixed payment schedule, if you're a public housing agency, you have the ability to choose that yourself. Public housing agencies also have the option of doing moves like either in-house, hiring somebody to do all the moves at once, or doing it in-house. That's an option for public housing agencies and not for other developing agencies. So the replacement housing payments, it's essentially just the difference between the previous rent amount and the new rent amount, right? If I'm paying $1,000 and then I get relocated and the only place I can find is $1,200, then the displacing agency should pay me $200 per month for 42 months to cover that difference. It includes utility repayments, and it is calculated at ION. So if the tenant moves, they're living in the new place, and then their rent goes up, you're not required to recalculate that payment amount. Or if their income changes or whatever, if the situations change, it doesn't matter. Whatever that amount calculated at ION is the amount it is. So you calculate this amount of ION, you have a monthly amount, you multiply it by 42, they're automatically entitled to that entire chunk of money. HUD does recommend paying in installments, but doesn't have a required schedule for that, what that is. So it's recommended to do it monthly, but that's not required. You do need to calculate people's income, because households earning below 80% of area median income should not pay more than 30% of their income at the replacement dwelling. So even if they're paying 50% of their income right now and move to somewhere that's the housing cost is exactly the same, they are only allowed to pay 30% of their income at their replacement dwelling. So you need to pay that difference, whatever that difference is between the 30% and the 50% that they were paying before. Finally, going back to the notice of eligibility, you're offering them 3 comparable replacement dwellings. You are allowed to use that to establish an upper limit for your replacement housing payment. So we mentioned the statutory limit, which is like irrelevant, but you, the displacing agency, can establish a cap for your replacement housing payment, so you're not just like gushing money. It should be, given in written notice, documented that it was received. The notice of eligibility is a great place to do it. So basically, you'll offer them, here's your 3 comparable replacement dwellings. All of them rent for $1,200 a month. And you currently pay, let's say we're still, same example, you're currently paying $1,000 a month. Here's 3 options that are decent, safe, sanitary, comparable. They rent for $1,200 a month. So we're going to cap your monthly payment at $200 a month. And then if you decide, the tenant decides, well, I don't like any of these 3 options, I'm going to choose somewhere else. Even if it's more expensive, it doesn't matter. The agency has, by giving this clear written notice, they've restricted their limit. They've restricted the amount of replacement housing payment they'll have to pay. So that is a reason why giving those 3 comparable units is really important, because it not only like gives the tenant some options, but it also protects you, the agency, as long as you're clearly stating that the maximum payment that you're establishing with these 3 comparable units. So I only have one slide, excuse me, on temporary relocation. HUD actually has a pretty good webinar on temporary relocation if you want to dive into this more. But just to go over it, temporary relocation, it has to be less than 1 year. The idea is you're rehabbing a building and only like having people out of their units for a short period of time, right? There has to be a guarantee that they'll be able to return to the same building or complex. And if for whatever reason your rehab goes terribly wrong and they are stuck out of their unit for more than a year, they're immediately considered to be permanently displaced, and all that permanent relocation assistance that they would have been eligible for, they are now eligible for. Obviously, if you're moving people 2 ways, both in and out, you have to pay for those moving costs both ways. And if the rent amount at their temporary replacement house unit is higher, then you have to pay whatever that difference is. So it's calculated the same way. If there's a difference between the 2 rent amounts for the time that they are temporarily displaced, you have to cover that difference. You could also just have them pay you rent directly and then pay whatever the per replacement housing dwelling is. That sometimes makes sense depending on the situation. Okay, record keeping. This is not a full list of all the records you need to keep under URA. There is an entire chapter of the URA handbook that covers record keeping. Everything needs to be in writing. And it needs to be kept for at least 3 years, 4 for CDBG, 5 for home, after the final payment is made. So get everything in writing, keep it in a nice place, store it under your couch, whatever, but make sure that that's in writing. Otherwise, we don't know what happened. So in the case that, that you have not complied correctly with URA, not a problem. I mean, it is a problem, but there are corrective actions that we can take to correct the issue. There's four corrective actions listed in the regs. So the first is failure to provide required notices. So if you didn't provide a notice and somebody moves out, then they'd be considered to be permanently displaced. And you must, quote, initiate all reasonable procedures to locate all former occupants. And reasonable procedures is outlined in the regs and includes appropriate notice in a local newspaper, checking with the post office for a new address, checking project records for places of employment, places of worship, other utility bills, talking to the utilities to see if they know where this person is, or hiring a finding service. So reasonable procedures is really broad, really needs to put a good effort into trying to find this person if necessary. So better to just issue those notices up front, because that's a lot easier than trying to find them after the fact. Obviously, if somebody is not paid what they are due, then you must ensure that the correct payment is made promptly. And again, you're going to need to go through all those reasonable procedures to find that person and give them whatever money they are owed. I've heard like horror stories of trying to track somebody down for a payment of like less than $100, right? So there are ways to correct underpayment, failure to provide notices, but better to just do it correctly the first time around, because then you won't have to. Inadequate replacement housing, if somebody for some reason ends up moving into some place that is not decent, safe, and sanitary, that's not acceptable. And you should either enable them to move to some place that is decent, safe, and sanitary, or repair wherever they're living so that it's decent, safe, and sanitary. Whichever that it is, this whole decent, safe, and sanitary thing is really big. And finally, relocation for minority persons. If you have not given your minority tenants an opportunity to move to an area of non-minority concentration, you must then give them that opportunity later if necessary. Again, just to recap, if a person is not treated properly under URA and affected negatively, they're considered to be permanently displaced. We talked about in the notice, in some of the notices, a notice to appeal if the tenant thinks that if they were not treated properly or they whatever they want to appeal the decision on your matter, you can put a date, you can give them a deadline that they have to appeal by. If you haven't issued those notices properly, there is no statute of limitations for appeals. So they can come back 20, 30 years later and say, oh, you didn't treat me properly, and you have to accept that appeal if you didn't issue those notices correctly. And in worst case scenarios, HUD can apply sanctions like termination, recovering their funding. Hopefully we never get to that point, because hopefully we've been able to go through the corrective actions and make everything right. But that is, the last resort. So we've gone over URA. There's another regulation that about relocation requirements, and that's 104D, which is 24 CFR Part 42. It applies only to home and CDBG, so not HTF. And there's essentially well, first of all, I should say that it's triggered by demolition or anytime, or conversion of units to non-housing, right? So anytime you're removing affordable units, then this 104D is triggered. So there's three parts to it. The first is that you must certify and follow a residential anti-displacement and relocation assistance plan. Now, highly recommend having a plan for your relocation regardless, but under 104D, it is actually required. The second one is replacing on a one-for-one basis all occupied or vacant occupiable dwelling units that are demolished or converted. So this usually is not a big deal, because usually, most of our agencies, most of you guys their purpose is to create more housing units. So this usually doesn't come up, but in the event that you're demolishing units, just make sure you're replacing them at least one for one, and not, converting them to a shopping mall or whatever it is. You need to replace those housing units. And finally, 104D also has relocation assistance payments as part of it. It applies only to lower income, so below 80% AMI, residential tenants. So for those tenants, whereas the URA applies to all tenants, including businesses, for the lower income residential tenants, they're entitled to 60 months of relocation benefits, calculated essentially the same way. Vouchers are allowed as a way to make those payments. Importantly, the tenant is allowed to choose whether they would like to choose the URA payments or the 104D payments. So in most cases, 60 months is going to give them, is going to be better for them, but they have that option to choose. There's a couple other minor differences. Security deposits, refundable security deposits are covered under 104D, but not under URA. I put a link here to the HUD comparison sheet if you need more details on that. And then finally, just next steps and resources. So the handbook 1378 I referred to a couple of times. This is the place I go to first whenever I have questions about URA. It's published by HUD. It just covers like all all the regulations and how they apply to HUD programs specifically. URA the HUD Way is a webinar series. So far, HUD has published, I think, an overview and a webinar on temporary relocation. So the temporary relocation webinar is quite good and quite detailed. There is anticipated to be several other modules, so I'm sure those will be interesting and good once they are published, and they are not yet available. So I don't know, check back on that link. Maybe at some point HUD will publish those webinars. That'd be cool. And I've linked also to the URA and 104D regs if you just want to, you know, if you're having trouble sleeping at night. So that's pretty much it. I think we have time for questions, and I apologize. I have not been checking the chat, so I will look at that now, and maybe I'll stop sharing my screen.
I've been checking chat. I haven't seen any questions in the chat yet.
Great.
Exactly, yeah. So if folks want to stick around for a couple minutes, we will keep monitoring the chat feature. Let's see.
Hey, okay, I like your comment about ice cream trucks. And unfortunately, now I want some ice cream.
Okay, so we have a question here. Can we talk about voluntary acquisition and how that applies to ION and GIN notices?
Yeah, so the ION date is still, in most cases, unless, like I said, you're a public housing authority, in most cases, it's going to be the date of the contract with the state. And the GIN notices are required either at the time of voluntary acquisition notice or the time of ION, whichever is earlier. Does that answer the question?
Teresa, we probably should add to there's been a common misconception of ION. And so one thing that I've been asking a lot of questions of before in the last couple of years is people thought that ION had to do with when the project became federalized. But when you actually get into 1378 and look for the real definition, it's, you know, and cut through all the details in that regulation, you'll see that ION is essentially the date that that home contract or that CDBG contract gets executed. And that's basically the starting point. Like I said before, like we've been saying throughout this presentation, that's the starting point. That's when you start the clock ticking, and that determines what your amount of relocation, you know, will be. But it's really important to get that nailed down, but it is not when the project becomes federalized. That's a common misconception.
As you were saying that, I think I misspoke a second ago. The GIN notice is due at the time of voluntary acquisition notice or the time of application, whichever is earlier. Right. Notice of eligibility and notice of non-replacement is due at the ION. I think I said that wrong a couple of minutes ago.
We have another question. ION is different based on the funding source. Is that correct?
Yeah. Yeah. So like I said, the URA has a definition, and then that applies unless there's a program specific definition, and each of our funding sources has a program specific definition, which in most cases is the contract between the state and the developer. So that's usually the ION, unless you're a non-private developer.
But Teresa, didn't we had one big one that it was not CDBG, DR, ESG, home, HTF, and it was one of the ETCs. It was one of the et ceteras. And they had gotten a huge contract from HUD that technically sort of been treated as an ION, and our understanding that it was not, so it caused a lot of headaches. So it's one of those things where you think that ION is going to be a straight black and white definition, and surprisingly, there's a lot of gray.
It wouldn't be federal funding if there weren't a little bit of gray.
Exactly. All right, so I'm looking at the chat. No other questions, it looks like. So just want to thank Teresa and Wayne again. Thank you guys so much for your time. This was an awesome presentation. Of course, our attendees can circle back, reach out to DOH staff should they have questions on URA. But in the meantime, you guys can go to our website. This webinar will be available and you can watch it anytime. I'm going to follow up with a survey to get your guys' feedback and any ideas on upcoming webinars. So with that said, thank you so much for your time and have a good day, everyone.
Thanks, guys.